Hello, everyone, and welcome to today's webinar by TVED Education Network. For technical assistance, please phone 03 8601 7709. This webinar is live and interactive. You're encouraged to post questions to the presenter by using the Q&A button. Your questions will be answered by the presenter during the session. I'll now hand you over to our speaker to begin.
Thank you, Jenna. And thanks to TVED Education Network for having me. My name's James Dapperchi. I'm a solicitor. I'm the principal lawyer of the law firm Graverman. I'm also the presenter of an online series of case summary videos called Coffee and a Case Note. What I'm hoping to do today is for all of us together to work through the law of corporate oppression. But before we do, can I just pick up on one admin point that Jenna raised a moment ago? I would like to double down on that invitation for you to just ping off any questions you might have as we go. What I often find in discussing corporate dispute stuff, derivative actions, just and equitable winding up, is that someone might ask a really good question 15 or 20 minutes in, and it'll give us a sort of useful set of facts or a useful way of thinking for us to kind of build upon as we work through the talk. So please consider that this is not a talk at anyone. This is a talk with everyone in the room. So please feel very, very open to hop into the Q&A and send through any cues in the hope that I might be able to A them or we might A them together as we work through the talk. Corporate oppression. Who cares? Why is it important? Why is it something I say you need to understand in the context of advising your clients? The short point is the violent potential outcome of oppressive conduct. It can be very literally an existential threat for a company if it's conducting its affairs or if a director is causing it to conduct its affairs in a way that is unfairly prejudicial to the minority. The thing might just get wound up. It might get its constitution amended. It might have its share register amended. There might be all sorts of changes done to the company if the sorts of conduct we're going to be discussing now can be found to have occurred. So I say oppression is not a nice to have in the context of a corporate advisor or a commercial litigator, indeed. It's a must have. And when I say must have, we don't all need to know the absolute minute details, but what I'm hoping to do today is equip you in quite a profound way with some of the broad thematic points that we're going to want to understand. And that'll be essentially what I'm going to hope to discuss in our session today. The structure that we're going to adopt is we're going to open up the first kind of like 15, 20 minutes or so, something like that. We're going to have a really sort of meaty, slightly boring, it'll be the hard part of the talk where we're just going to really work through Section 232 and Section 233 of the Corporations Act to make sure that all of us together understand those sections and understand some of the helpful things that have been handed down from the bench over the years to assist us in understanding how those sections work. So that'll be the first section. The second section of the talk will be case summaries. We're going to get into a few different pieces of litigation that we've chosen today that hopefully are going to highlight some of these points and help us understand in more depth what we've learned in the first part of the talk. And then the final part of the talk will be embarrassingly probably the shortest part, if previous experience is anything to go by. But it's going to be very much a kind of practical nuts and bolts sort of approach. And if I can spoil the ending now, where we're going is it is not in your client's best interest to run one of these suits, right? And so the view I'm going to take is that we want to negotiate, we want to think about shareholders agreements, we want to think about how we avoid this type of litigation. So that's really going to be the heart of that practical discussion. If we jump into some of these preliminary comments, what I say is that oppression concerns the shareholding and directorship of companies. This isn't executive day-to-day stuff. This isn't a contractual dispute with a supplier. This isn't a, weird kind of nuisance flavored dispute with a neighboring property owner or a neighboring business or whatever it might be. This isn't an IP dispute. Well, it isn't necessarily an IP dispute, although often confidential information becomes more relevant than IP in these sorts of disputes. This is what we might think of as one level of abstraction, sort of above the day-to-day operations of a business or indeed of a holding entity, an asset owning entity of some kind. We're up in the level of the top executive slash into the boardroom, the board of directors. These are questions about how is this entity being run, who's running it, and what's going to be happening in relation to the future. So the view I take is that if you're in this room, regardless of whether you're a commercial person, regardless of whether you're an estate planning or estate litigation person for people who might have high net wealth and some complexity to their affairs, or if you're a commercial litigator or anyone like that, an insurance litigator indeed, having an understanding of this area of law that really affects the foundational building blocks of how companies operate is going to assist you. Or at least that's my hope, and indeed that's my sales pitch for why it's a good idea for us all to be in this room speaking together. So let's get into the nuts and bolts. Let's start with the nut of Section 232 of the Corporations Act. This is what a colleague's helpfully referred to as the door question. Can your applicant or can the applicant who you are opposing walk through the door of corporate oppression? I'm not going to reduce everyone to tears of boredom by reading through Section 232 verbatim, but I might spend a moment reflecting on how it works with Section 233 while we linger on this slide for a moment. Section 232 essentially says that the court can make a Section 233 order, and we're going to come to what that form of order might be. But 232 says the court can make a 233 order if the way a company's affairs are being conducted, were conducted, or will be conducted is sort of unfairly prejudicial to one, some, or all members of the membership of the company, and we might use the term member and shareholder interchangeably today. As almost all of you will know, a member is not absolutely identical to a shareholder. There are distinctions in what those words mean, but for today's purposes, today's discussions, we're going to treat those words as interchangeable. So, we are dealing with a section that says you can get your 233 order if past, present, future conduct of the company it's prejudicial to one, some, or all members. And I might just linger for a moment on the breadth of this section, right? If we draw in future conduct, and future conduct, we're not talking about hopping in the DeLorean here, as you might imagine. If you're going to move the court to make some orders, it might be a proposed transaction of some kind, or there might have been a proposed meeting where a certain question is going to be raised and the vote might seem almost inevitable, and so there might be some form of injunctive relief contemplated. It's not just merely the company's got to be run in a nice way and into the future. There'll need to be some future conduct that your applicant client will be able to point to, or indeed some future conduct that your respondent client will be able to adequately explain and tangle with. And I might just add on a bit of it. I might just tangle with that final bullet point you can see in front of you a little bit more as well. We sometimes, certainly at university, this area was described to me, as I vaguely recall it now, as minority oppression or something like minority shareholder oppression. Now, it is a very valuable tool for apparently mistreated minority shareholders to use, and I don't want to for a moment walk away from that suggestion. Minority shareholders can use the area of corporate oppression to great effect in protecting and projecting their interests. But, or perhaps it is not merely for a minority interest. There's no mathematical issue that says, oh, once you're over to 50%, no more oppression relief for you. Quite the opposite. The oppressive conduct, if we describe it loosely, that unfairly prejudicial conduct can be unfairly prejudicial to one, some, or all of the members, the shareholders of the company. So I'd like to just make that point crystal clear. And as you might imagine, sometimes in like a wills and estates kind of context, you might have shares that formed part of a person's estate who's passed away. The executor might sort of come to own, a large majority of the shareholding, but there nonetheless might be a misbehaving director in place who's off doing some crazy things, and the executive themselves might not be in a position to become director themselves or appoint a director of their own, despite the shareholding. And look, I'm creating quite a complex hypothetical that I'm sort of picking apart as I create it. But the short point is that there's no numerical test that must be met in order for a shareholder to be able to bring an application of this kind. And so, if I can just refresh your memory of the basis for Section 232, what that section says is the court may make a 233 order if this past, present, future unfair prejudice to 1%, 49%, 50%, 100% can be shown. So the court may make a 233 order. And so we might ask ourselves, well, what's a 233 order? Now, I would direct you to the section when you're giving advice on this point, because no matter how many times one tangles with this area, there seems to be new stuff that's just magically put in. And I say that as a criticism of my own memory and not a suggestion that the section's amended often. It is not amended often, and I'm not even sure it has been amended since 2001. But the criteria, I withdraw that, the range of orders that might be made pursuant to Section 233 is very, very broad indeed and includes Section 233J that the court may make an order requiring a person to do a specified act. Or Section 233I might be to restrain a person from engaging in specified conduct. And so the court can, pursuant to Section 233, get someone to do a thing or stop someone from doing a thing and all sorts of other stuff as well. Now, I'm speaking about that in a slightly loose and casual way because where I'm marching towards is not, we'll think carefully whether you're seeking to have a receiver appointed, a receiver manager, a liquidator, a provisional liquidator, or whether you want to get injunctive relief and, empty out the board and appoint an independent board of directors, or are you going to amend this section of the Constitution, or what are you going to try to do? With great respect to the consideration that must be given in crafting Section 233 relief when you're drafting your application, the commanding majority of relief sought pursuant to Section 233 is sought on an alternative basis. Alternative one is a share sale. Alternative two is a winding up. So despite the breadth of 233 and acknowledging the breadth of 233, what I'm going to suggest to you today and what I invite you to accept is that even though a party, an applicant who meets that 232 test, who walks through the 232 door, can walk through that door and start choosing a 233 order, and they might have an abundant, I guess, infinite almost choice of what they might like to do. That choice will almost always narrow down to, are they going to be seeking a share sale at fair value? We may well have time to come back to that point, or a winding up of the company. So let's just kind of linger on what we've learned in a peripheral way before we get into some of the lessons we can draw from the cases to understand this all a bit better. We have Section 232, your kind of threshold section, your door you've got to walk through, and potentially work through as well. Can an applicant move the court to make a 233 order? Well, they can if they can show past, present, future conduct to 1%, 49%, 51%, 100% is being engaged in unfairly prejudicial conduct, is being engaged in by the company. If they walk through that door, the court may make an order. So remember, it's discretionary. This is not a derivative action application where we might think of once the boxes are ticked, you just go straight ahead. This is an oppression application where the court retains its discretion, and we're going to come to how that discretion can sometimes be exercised in a little while. But the lesson we drew from 233 was, despite the very broad range of orders that might be made pursuant to 233, I invite you to accept that we're really narrowing it down to, does your applicant client want a share sale, or do they want a winding up? And the alternative, are you resisting an application on the basis that a share sale is being sought? or a winding up is being sought. And so, unfairly prejudicial conduct, almost unlimited ranges of orders we can seek, like all this stuff is quite fuzzy and complex. And I'm pleased with myself in the past to spend some time drafting a paper that I've got in front of me here. I'm going to glance down and you'll hear me turning the page a couple of times to make sure I extract some value out of that for you for us to continue discussing. But when we're reflecting on how an application of this kind might proceed, what I'd like you to bear in mind is that the purpose of the relief is to cure the oppression. And so it's not quite a question of so you have a breach of contract where there might be sort of a nominal damages order made if there is no if there is indeed a breach, but there's no loss that can be shown as a result. There's an analogy here to be drawn that it's not merely a question of showing there's unfair prejudice. Section 232, wow, 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 that was unfair. Well, maybe it was, maybe it wasn't. The real question for your applicant client, and indeed the real question for your respondent client, is if that is so, if there was unfairly prejudicial conduct, what is the court going to do about it? And the answer, if there's no oppression you can point to, is the court is going to do nothing. We're going to come to an example that really teases this out. The authorities are pretty useful in this area, and I say it's going to be worth diving in if you're giving some advice or if you're making your way through it. There's a decision called Tomanovich that was heard at first instance by Justice Austin in 2010, and his Honour there set out a number of useful ways of thinking about how the bench ought to treat oppression applications and the sorts of issues that they ought to bear in mind. One of them, and one of the more important, is this possibility of baiting. So judges say that judges must not remain. Sorry, His Honour says that judges must not remain in their ivory tower, and he's picking up on a line used by Justice Young back in the mid 1990s in a case called Fexuto on that point. And the short answer, the short explanation or extraction of that comment is that an oppression suit can sometimes be brought by someone who might turn out to be the real agitator, the actual person who's causing all of the unrest and unhappiness and challenges in the management of the company. And the judges must not remain in their ivory tower. They must be alive to this potentially baiting question of the, whatever the analogy might be, of the pulling the pigtails until you get, hit in the head on the primary school playground or something like that. We've got to be alive to this baiting issue. Justice Stevenson, in what I consider to be, with great respect, a very useful decision of 2017, we're going to come to the facts of it later in the discussion, called Munsterman and Raywood, works through a really, respectfully, usefully large number of authoritative statements that we can apply when we're working through our views and augmenting our ability to work through the law of corporate oppression. His Honour clarifies that the task the court is faced with is to determine whether, on the balance of probabilities, so the balance of probabilities question, it's a civil question, the objective bystander would be satisfied the affairs of the company were being conducted unfairly. Sometimes thought of as would an independent director looking on, that kind of test of the question is not how's everyone feeling about it? Do they feel like it's unfair? This kind of thing. We're kind of trying to draw out, similar to the comment His Honour Justice Austin made in relation to the ivory tower and the baiting point. We want to zoom out. We want to get an understanding of the conduct. And we want to say, well, what's an objective person looking at this conduct going to conclude about whether it's unfairly prejudicial or not? A number of other very important points. A director might cause a company to engage in unfairly prejudicial conduct, but not be in breach of their director's duties. And another point that I'm going to piggyback on before we discuss these two together, conduct of a company's affairs might be otherwise lawful and nonetheless be oppressive, if we just linger on that for a moment. So the issue of additional shares that your client might complain has the impact of watering down their holding, of diluting their holding of shares. It might be entirely in compliance with relevant, shareholders agreements, let's say. It might be entirely consistent with directors' duties. It might be entirely consistent with the relevant Corporations Act and sort of ASIC obligations and this sort of thing. And despite complying with all other relevant law, including directors' duties, including shareholders' agreements and whatever else, it might nonetheless be oppressive. So let's linger on that point for a moment, that unfair prejudice is not dependent upon there being a finding made that there's been a breach of the shareholders agreement or the constitution or something like that. It's an entirely separate point. Conduct that has the effect of paralyzing a company can form an oppression application. And I don't want us to dive too deeply down this rabbit hole, but for those of us in the room who've had the opportunity to discuss this issue with clients in the past, what I would invite you to think about, and something that may jump straight into your head, is the question of a just and equitable winding up. So if we're talking about the paralyzing of a company, what you and I might think of is like, that sounds a fair bit like a deadlock in a company or something like that might justify an order being sought that it be wound up on the just and equitable basis. That's a different chat for a different day. And sorry to glance over at the chat. Oh, Jenna, you're very kindly sharing the resources. Jenna, thank you. Everyone, please feel free to jump into those resources, of course. And if you are a follow along type person, and you're jumping into the paper, I'm at paragraph 14. I'm now at page 5. Paragraph kind of DEF is where we're dancing along. There's no need to glance at that now unless you'd like to, in which case you're very welcome to. I'd like to be very clear as we move now to paragraph G, 14G of the paper. And this is the timing question. This is the final bullet point on the slide you'll be able to see on your screen. What I'd like us all to understand, and we might understand it a little bit now, and I promise we'll understand it a little bit more as we move through the talk, is that in relation to timing, there are two very important points to be made. The section 232, walking through the door point, which I've described as liability in that little sub point, the question of was the conduct unfair in the past? Is the current conduct or will the future conduct be unfair? That question is to be answered at the time proceedings is commenced, right? Well, I guess you don't really have a junior run down to the registry anymore, do you? You use the account you've got with the online registry, and whenever that originating process is filed, that's what you're doing. That's where you go, and that's what happens. And so that 232 question, is it unfairly prejudicial? The time that question will be asked will be at the time proceedings are commenced. This is going to seem like a slightly obtuse point, but we're going to populate it and it's going to make sense, I'm sure. The question about relief is a final orders question. And so everyone in this room, or a commanding majority of the people in this room, is going to have the experience of running a piece of, medium complexity, not extreme complexity, but kind of moderate complexity corporate disputes work. And you know that if you commence in 2022, a couple of interlocutory fights along the way, a couple of delays here or there, you might have a couple of warring forensic accountants or what it might be. It's probably only going to be 3 or 4 years later, probably about now for your 2022 proceedings, that the final hearing might be set down, perhaps later this year or early next year. Now, if we think that through, the 232 question is to be answered at the time you commence proceedings in 2022. The 233 question, are you going to get the relief, next month or early next year or whatever the time of the final orders being made is? 3.5 years passes between those 2 points, right? And we're going to come to an example that really puts the flesh on the bones of 232 is about commencement of proceedings. 233 is about final orders being made. And I promise by the time we end that phase of discussion, it's going to make good sense to us all. In relation to a winding up order, what I would like us to hang on to is the idea of winding up being a last resort. And there'll be attendees in this room whose mind jumps straight to Section 467, subsection 4 of the Corporations Act, that concerns when an order for winding up a company on the just and equitable basis will not be made, despite it being just and equitable for such an order to be made, if there's an alternate order. This has a similar, well, I was going to say identical. I think maybe I mean identical, an identical operation to Section 467, sub 4, in the context of just and equitable winding up. The short point is that winding up is a very violent piece of relief, appointing a liquidator to a company's affairs, to a company to sort of take over, as everyone in this room well knows, and it will be treated by the court as a last resort. And so, why am I raising that in this context? It's in the context of you thinking about the Section 233 orders you might be crafting for your client. Remember, you're painting from an unlimited palette with all the colors, but you're really choosing between the red and blue of share sale or wind up. And it's worth bearing in mind this line of authority that says a winding up order is genuinely an order of last resort. And we'll come to a case that deals with her like, is it really last resort or is it just an extreme thing? We'll come to that shortly. Now I'm going to take a sip of this lovely cold drip coffee over here. I might repeat my invitation to everyone here, and I'll issue an apology because some of these cases are underlined and some are not. I've got no useful explanation for that. They are not to be distinguished. Oh, there's a nice typo in one of them as well. Daiwakan Company. Well, that's a nice set of slides for you. Hopefully, I haven't replicated those typographical errors in the papers, but there we find ourselves. So I might, if I won't take a sip of coffee, I'll take a sip of water, and I might repeat that introduction to everyone here to say if there are questions or just funny little points you'd like to work through, feel free to throw those. I can't see the chat at the moment. Feel free to throw those in the open questions situation. I'll take a sip of water and we'll get back into it. Okay. The first case I'd like us to discuss, and just confirming that we've now moved into the second phase of the paper. So you've started with eating your vegetables. Remember, because today we're talking about the law of corporate oppression. You've done that. You've eaten your vegetables. Now we're moving on to the protein. You might be a vegan person, and we might be having a nice bit of delicious tofu or something like that. You might be a omnivorous person, and we might be moving into steak. That's great. That's what we're doing now. We're sort of getting into that. And don't worry, there'll be dessert at the end. We might have, vegan ice cream for some, dairy ice cream for others. I don't know a lot of desserts with meats in them, so we can leave that aside for the moment. Shanahan and Jatese, if I can ground your thinking, this is a case that I hope assists you with that timing point, among some other points as well. This case relates to a company that owned and operated an eye hospital in Canberra. Now, this eye hospital did what I understand eye hospitals to do, which is patients would come in for some eye surgery, surgeons would conduct that eye surgery, and then the patients would pay money to the hospital on account of that surgery. Now, the surgeons, each of the people doing the cutting and the gluing back together of the eyes, would do that work. They'd provide their services to the company. They were also the shareholders, the owners of the company that was operating the eye hospital. Time passed, the thing made money, it was solvent. Time passed, and a large minority of the directorship of the company, and the shareholding of the company retired from full-time surgical work, and they headed off to the golf course, or they headed off to South America, or they took a cruise around the Antarctic, or whatever retired people might happen to do. But they remained shareholders, and while they were shareholders, they continued to derive an income from their shareholding in the eye hospital. As you might imagine, what might be, with great respect, potentially a fairly natural human response, the majority directors who continued to exert themselves, cutting eyes open and fixing them and gluing them back together and doing whatever they do, and seeing all the money they made for that, or 43% of the money they made from that flowing out the door off to the golf course, they became unimpressed with that situation over time. What they did was a number of things that, spoiler alert, were found to be unfairly prejudicial. One of them was to put really weird procedural impediments to the appointment of new surgeons, and those surgeons would have got the company back on track onto doing some really useful, profitable work, despite the fact it was still solvent. They also caused the appointment of a voluntary administrator to take over the affairs of the company despite the fact it was still solvent. And in this context, the court had some comfort in finding that the conduct of the company's affairs was unfairly prejudicial. And I have not told you that during the course of the litigation, there was a mediation that occurred. At that mediation, a deal was struck. The deal that was struck was that our minority shareholders out on the golf course or whatever it might be would sell their X percent, I think it's about 40%, 45% of their shares for some amount. I think it's in the high ones, let's say 1.7 million, as well as X percent of the inventory in the hospital. So there's this deal struck. We all shake hands and go, all right, we'll sell your shares. And those shares were sold pursuant to that deal that was struck. Crucially, the litigation was not settled. Does that make sense? So the doctors, the minority, remain litigants with the application on foot, but they are no longer shareholders from the time of that mediation because they've sold their shares. Let's flash forward to the final hearing, because remember, now we see that they've walked through the Section 232 door. They have proved to the court that, yes, indeed, the appointment of this VA and the sort of strange prevention of the appointment of some new surgeons was indeed unfairly prejudicial to one, some, or all members. In this case, 43% of the members, or whatever it might be. Crucially, we then move to the next step, and the court considers the price that the minority got for the shares that they sold, while the litigation was on foot at this interlocutory stage where there was a mediation. What the court did was compare the price achieved by the minority in that transaction and the fair value for the shares at that time, and found that they'd in fact achieved a sort of super outcome, an outcome over and above the fair value of those shares. And what that meant, the court found, was that there was no oppression to be cured by the orders, because as you'll remember, any Section 233 relief is to be crafted to cure the oppression that exists at the time of final hearing. And so back on this timing point, our applicants here succeeded in those bottom bullets down there, succeeded in proving the liability, the unfair prejudice at the time proceedings are commenced. But by the time of final orders, they had escaped and they'd made off with a super profit, a sort of an excess payment, more value than the fair value for their shares. And so the court was not minded to order relief despite the applicant's success on the 232 point. So they won on 232, but they lost on 233. You know where I'm going now, and that's the question of costs. What the applicant said in relation to cost was, well, yeah, we didn't get our 233 orders, but the real hot dispute where so much of the court time and so much of the evidence and so much of the subs was all directed, all these legal fees were really directed at Section 232 sort of issues. We won the 232 point, and so we should get a commanding majority of our costs. In the alternative, each party bears their own, something like that. What the court had, with great respect, little difficulty finding was no, that was not right. That the applicants had brought proceedings seeking certain relief. They didn't get the relief. Cost followed the event. And so the defendants got their costs. The majority ended up succeeding in that piece of litigation. And what I'd like us to extract, a few things I'd like us to extract from that decision, if we can, is firstly, almost that ivory tower sort of point. It's not quite baiting, but there's an element where we might have felt sorry, firstly, for the poor old majority who are seeing their profits flow out the door to the golf course. And then we might have felt sorry for the poor old minority who are having, the appointment of a new surgeon being prevented and the VA being put in place. And then what we kind of find is, despite these initial impressions we might find of like, oh, that's a bit mean, we might say, speaking loosely, there's a necessity for the court to really get into the detail and get into an understanding of precisely what's gone on, to do the maths of what share value did you get a couple of years ago when you sold them versus what was their value just then. And we find that engaging with the fine detail of the issues leads the applicants to fail in this application. And indeed, that first instance decision, I think it's of Justice Hammerschlag, if I recall, is upheld on appeal about a year later. So we now move to the decision of Knights, Quest, and Daiwa Can Company, as the as the slide would suggest in front of you. Let's turn to that case now. What we sometimes think of is that a company is controlled by directors, and so that the conduct of a shareholder is not something that's going to affect us very much. The analogy I sometimes draw in giving advice, and you might draw a similar one, is the shareholders of BHP, right? So I might behave in whatever way I like as a shareholder of BHP, but you don't have a claim to bring against me because I'm not a director of BHP. And it's often that directorial role, that controlling sort of role, that would ground or found a sort of application we might tend to see in the context of disputes about disputes from shareholders. Here we have an interesting set of facts where oppression proceedings are commenced against a majority shareholder or in relation to the conduct of a majority shareholder. Let's work through this a little bit. We have a transaction that occurs in or around 2012 between a number of entities. There is what we might think of as a parent entity based in Japan who is a can manufacturer. And the can manufacturer purchases 60% of the Australian wine for use in wine in a can sort of marketing company. So we've got this Australian company making wine to be put in cans, Japanese company that makes cans, and the Japanese company becomes a shareholder of the Australian winemaking company. Now, at the time of entering into this arrangement, the Japanese company had a subsidiary that was also a winemaker making wine to be chucked in cans made by the Japanese parent company. And so we have this sort of moderately complex situation, at least from the perspective of the Australian entity, where the Australian entity is majority owned by a company that also majority owns another company that might be seen to compete in some ways with the Australian company. And indeed, the Australian company takes the view that that is the position. So over time, we've got the Australian company's performance slackening, tensions are rising, and there's a suggestion that the Japanese parent company and potentially the subsidiary are using wine canning techniques that belong to the Australian company and not to the Japanese parent. But in short, the Japanese company commenced proceedings seeking to wind up the Australian company. The minority shareholders in the Australian company commenced an oppression suit seeking a share sale. Now, at first instance, the oppression suit was dismissed. But on appeal, there was this question about whether you can sue a majority shareholder on account of oppressive conduct. There was this consideration of an ancient Scottish decision about rayon manufacturing that was followed and found to be of use in considering the point. And the short point was that the conduct itself was not found to be commercially unfair. So what the Japanese parent company was doing in relation to the wine canning techniques and the competition of one of the companies it owns a big stake in competing with another of the companies it owns a big stake in was not found to be commercially unfair or unfairly prejudicial conduct. But on foundations, but despite the fact that the applicants failed on that oppression claim for the reasons I just explained, the court nonetheless found, yes, you can pursue a majority shareholder. It's just that in the very specific fact pattern of this case, pursuing the majority shareholder failed. So what I'd like you to take from that case, sorry, before we glance along, is that when you are selecting your respondents, when you're selecting your defendants, it is open to you to reflect upon whether there is some majority shareholder that you want some of those 233 orders to attach to. So even though I've said, look, it's pretty much share sale or wind up, I guess you'd potentially want a share sale to or from that majority shareholder, but you're going to want to turn your mind to where we want these orders to bite, and you're going to want to think nice and carefully about the constitution of the proceedings based on the relief that you might be instructed to seek. Similarly, when you're a respondent, when you're working through the prayers for relief that are put before your client, you're going to want to turn a reasonably critical eye to say, okay, well, um, how do the pleadings lead to this particular head of relief here? Why would what have I read on this list statement or OP or statement of claim or whatever it might be that might lead the court to exercise its discretion in this direction? That'll be a question for you. Now, time has moved faster than I would have liked, which means we're not going to get to all of these cases, nor all of those cases, and we won't get the most time for practical suggestions. So I'd like to firstly repeat an earlier invitation about any questions you might have. Do please hop into the Q&A. I'd love to try to A some cues before we go, but I'm just going to try to sort of steam ahead and see how far we get, noting the deadline that's approaching. Let's head to what I have called golf club shenanigans in the decision of Falkingham. We're not going to spend the longest time on this case, but what we have is an oppression application that fails on 233 basis. So that'll spoil the ending for you. We've got a tale of two golf courses. Essentially, it's a golf course merger scenario. And the nature of the merger is that golf course one and golf course two form the view they're going to merge, potentially for financial reasons. That kind of seems to be in the background of this. Golf course two is going to sell its course for development and going to derive a significant amount of income from that sale. Golf course two is going to merge with golf course one. Now, of course, merge doesn't really mean anything. What happens, in fact, is that golf course one is going to be renamed with sort of a joint name, and the members of golf course two are going to be sort of transferred without charge to those members or whatever it may be, away from golf course two and into golf course one, and so that the sort of newly enriched golf course one has the outcome of this transaction, in its coffers, and has a whole new membership base that's come over from golf course two. An applicant brings an application on the basis, essentially, to try to unpick this merger between the golf clubs. Now, what is interesting is the basis upon which those orders were not made, and that's what I want to linger on for a little while. At first instance, and on appeal, or in fact, the point wasn't really necessarily raised on appeal. At first instance, the plaintiff was successful on the 232 point. What the plaintiff was able to show was that the power to admit new members, so that the board of Club One's power to admit all the new members for Club Two was not a power granted for the sake of golf club mergers to be made. And so the power to admit new members was exercised by the board of Club One for reasons other than the reasons that power was conferred upon the board. And so when you've got directors using their power for reasons other than the reasons that they should have, you have got an applicant who is able to walk through the door of Section 232 and succeed on that basis. And that indeed is what happened here. So we have the applicant at first instance walking through the Section 232 door. As you and I well know, and as we were, as our memory was refreshed and we dealt with Shanahan and Jatese, walking through the Section 232 door is different to getting Section 233 relief. And so the court exercised its discretion in not ordering 233 relief due to acquiescence and delay. And more or less, the plaintiff was too slow. And if I might respectfully read between the lines, there's some complexity to this transaction. And so the complexity and value to this transaction. And I say with great respect, there may have been something of a real world approach adopted by Their Honour at first instance and Their Honours on appeal, adopted to the idea of unpicking the transaction based on what might respectfully be thought of as a somewhat minor administrative sort of breach or administrative stretch of, administrative overreach, if I can put it that way. There's then an appeal. The plaintiff appeals. And the short point is that the Court of Appeal finds the trial judge was correct in the 232 finding. But on the appeal of the 233 discretion, what the appellant failed to do on appeal was to establish that there was some acting upon a wrong principle, all the various bases for bringing a discretionary appeal, taking into account an irrelevant matter, ignoring something that is relevant, reaching a result that's plainly unjust or unreasonable. I think that's is it the king, is it R and the king, or whatever it might be. You're likely more familiar with those criteria than I am, but the short point was that the plaintiff was unable to show on appeal that the exercise of that 233 discretion was improperly exercised, such that the appeal ought to get up, because the appeal did not get up. Failed. So let us now jump ahead to Asia Pacific Joint Mining. I'll just spill some water over myself as well, in true James Dapperchi style. This decision relates to an application for some somewhat closely held, so relating to some somewhat closely held entities. We have some sort of mining and mining adjacent sort of companies who are interacting in Queensland. There are some complaints made about conduct at first instance. An applicant brings a Section 232 and 233 application, an oppression application, to seek relief. What happens is that the 232 door is worked through on first instance. The court says, yep, that's fine. And the first instance decision is that the Supreme Court ordered a share sale. Sorry, I withdraw that, ordered a wind up. And the respondents, I withdraw that, the respondents at first instance, the defendants appealed. And the basis of their appeal was that the ordering of a wind up was not the appropriate form of relief. Does that make sense? So no one's arguing about whether the plaintiffs at first instance were unfairly prejudiced and able to walk through the door of Section 232. The sole argument is the defendant saying, hey, yeah, you got us. But instead of ordering a wind up, a share sale is the appropriate remedy. And you might remember earlier in this discussion, I might have said something to the effect of a wind up is a remedy of last resort. And this is kind of a phase of the discussion where we can get into what we really mean when we say that a winding up is a remedy of last resort. The question sort of becomes, well, is that really right? Is it really a remedy of last resort, or is it merely an extreme step? And the Court of Appeal, Queensland Court of Appeal here, is forced to kind of dive into that issue in some depth to be like, hey, look, winding stuff up's pretty intense. We've got employees. There are people who have contracts with companies. There are people who rely on companies not being wound up and continuing to march on. There are costs associated with what we might think of very loosely of sort of legal phoenixing, if I can frame it that way. There are issues that can arise even in totally appropriate and lawful circumstances where a company's wound up and a new entity ends up stepping into that sort of gap in the market. And so, it's right to be reluctant and slow and cautious in coming to order wind up proceedings. And what the court finds is that in order to wind up a solvent company for those reasons is somewhere where caution should be exercised. And it is indeed an extreme step and should be thought of that. But it is not, speaking technically, a last resort. It is not that a plaintiff must show, or an applicant for an order for a wind-up must show, that every single other possible avenue for relief has been entirely exhausted before a winding up order is made. There are analogies drawn here, as I'm certain you would have already imagined, to the interaction between Section 461 sub 1K, just and equitable winding up remedy, and the operation of Section 4674 that sort of says, look, if it's just and equitable wind it up, the court can also consider some other avenues as well. Here, the court finds that yes, indeed, winding up is an extreme step, um, and says that despite this, the court will stand by the first instance decision to order a winding up for three reasons. Valuation of the shares in this case is going to be expensive, including because there's this unlitigated claim which might amount to $33 million. It's a chosen action in the hands of the relevant company. And so it's like, well, how do you value that? That's a real valuation challenge of, an unlitigated chosen action that might be worth 33 million. Ooh, how are we going to think about the value of a company that has an asset like that? There are serious doubts that were not allayed by the evidence as to whether the applicant had the capacity to pay, capacity to itself fund any purchase price, because any purchase price is likely to be in the tens of millions. And so the court would want to find itself in a position of ordering a share sale of 60 or 70 million or some, reasonably substantial amount, and only to find the applicant having to go out backwards or being unable to fund it themselves. And then thirdly, and with great respect, operatively as well, the court finds that there are sort of entities related to the defendants who would have had the financial heft to stand behind the defendants and essentially to guarantee their obligations to go ahead with the share purchase. And there was no such guarantee offered, no such funding offered. Time's marching on. I want to get to practical considerations, but what I hope you take from discussing Asia Pacific joint mining is that winding up is an extreme step, but it is not an absolute last resort. And there are times when it is an entirely appropriate step for an applicant to take. Hunter and organic, I'd love to just discuss this when I flick through to the practical suggestions I'd like to make to you. Hunter and organic related to essentially a restructure where a shareholder in an entity was a shareholder in a trading entity. There was a restructure whereby the trading entity assigned all of its IP and know-how to the trustee of a unit trust. And so the trading entity essentially ran bare. It had very little assets. It paid all of its assets out each month. All of its profits out each month into the holding company, essentially a unit trust. That was then distributed to various discretionary family trusts. And our five shareholders formed three groups, if that makes sense, to benefit as beneficiaries through a distribution from their family trust. So the five shareholders in this trading entity own shares in something that's not worth anything because all it's doing is trading, and they take the benefits out because it's paid to the unit trust. Unit trust distributes to the family trusts, and then they take as beneficiaries down here. Now, there is a family law separation between two of the shareholders, and as a result of that, this shareholder, the applicant, has no entitlement to take distributions from the relevant family trust. And so the position is there's no way for them to get money out of this arrangement now that it's been entered into. And I should just say they approved and signed and got advice entering into the arrangement. And so we have this outcome that our unhappy applicant is unhappy with. They attempt to move the court to order relief pursuant to Section 233. Court is unmoved. And the reason for that is that this applicant is unable to point to any oppressive conduct. There is no conduct itself that the applicant is able to point to. So the outcome might be thought of as sharp. It might even be thought of as unfairly prejudicial, but there is no conduct for an order to attach to, and that is why the applicant fails in that case. Let's take a quick tour through some practical suggestions, and this is quicker than I would have liked. If you encounter facts relating, facts of the kind we've discussed today, where we've got co-owners or people in charge of an entity unable to get along, unable to agree on what that entity should be doing, like essentially you're going to agree or you're going to litigate, and you all already know that. And so I'm not planning to linger on that for too long. But that question is, well, if you're going to agree, if you're going to agree, I was just checking the chat and then removing the chat, which is always good fun. if you're going to agree, what are the terms of that agreement? When's the best time to write a shareholders agreement? 20 years ago. When's the next best time? As soon as you can, right? So if you've got a dispute going on, do your very best to try to head off that dispute, finalize it, record something in writing that's going to help the parties march on into the future, into the sunset together. There are some suggestions in the paper for the sorts of terms you might want to get involved with. But if I can sort of linger for a moment on a couple of super relevant points, an exit strategy is going to be very, very important in any agreement that you're going to craft. You're going to want an accession sort of position. How do we bring new people in, get rid of them? And I say a management structure that might include a chain of command can be pretty useful as well. A lot of people try to deal with this in like reserved matters and this sorts of things. And in my experience, if you have people who are already misbehaving, it almost gives them more ammunition to misbehave further. So I think you want to really nail down what everyone thinks the structure is. What I'd like you to do is that second point, and the third point that I'd really like to just sort of linger on pretty seriously as not just an opportunity to successfully solve a legal problem, but to sort of grow your practice and provide more assistance to your clients. I'd like you to, that second point, I know it sounds a bit touchy-feely, but it's to sort of embrace your power to head off issues like these, to do a bit of issue spotting, to be able to form that sort of relationship with your client where you're the trusted advisor, and to be able to say, hey, look, I went to this presentation about these sorts of issues. It's ugly litigation. I want to help you avoid it. Let's try to get into this to see if we can head it off in some way. And so something I've had sort of non-failure with is a kind of sort of in-house type approach. Some people call it an audit, where you might say, hey, look, let's just look through your governance documents. Let's have a chat about how you're running things. And let's try to think about how closely the way you've got a written down recording of what you want to do aligns with how you're actually running your affairs in this company. And there's a chance, I say, that there'll be entities that you act for that find themselves in a position where those entities have one set of rules for how they should be running things and have an entirely different course of conduct that they're engaging in. And so I'd encourage you to embrace that kind of in-house approach to sort of get an understanding of how your companies, your client companies operate, how they manage their affairs. And that final point is, I mean, we want to avoid litigation. If there's litigation going on, especially in the corporate oppression space, lawyers win. I'm all for lawyers winning. I'm all for you winning and all that sort of stuff. But the best advice for our clients, and I'm certain you'd agree, is to avoid litigation if at all possible. And so my hope is that our discussion today has allowed you to sort of have some understanding of that path there. What I'd hoped to cover today, I'd like to just recap quickly, is that hopefully you agree that we sort of kicked off by really getting into the nuts and bolts of what the law of corporate oppression is all about, Section 232 and 233. Then hopefully, although we didn't get to all the cases, we put some meat on the bones, meat on the nuts and bolts, and got ourselves a bit more of a deeper understanding of how we're going to work through these issues or what happens when the rubber hits the road. And then a couple of practical suggestions to close that I say involve you embracing the knowledge you have and the trust that is placed in you as your clients' lawyers to sort of march on into the future and sort of elevate the service you're providing. You know, you're not just a litigator who does arguments. You're someone who's experienced in solving these sorts of problems. You're not just a commercial lawyer who's coming along for the CLE point. You're someone who has the power to use your knowledge of business structuring and transactions to head off some of these issues. And I'd encourage you, for your own benefit and the benefit of your clients, to embrace that power you have that hopefully I've augmented ever so slightly today. I don't see any questions. I'd like to thank you all so very kindly for your attention. Big thanks to the Education Network for the opportunity to speak with you all. And I might also say that if you'd like to find me online, you can sort of Google my name. I've got an online series of video case summaries called Coffee and a Case Note. My law firm is called Graverman. I'm very, very grateful for your company. I hope you took some value from today's discussion, and I hope you enjoyed it, even a fraction of how much I enjoyed it. Thanks so much for your company.
you, James, for a great session today, and thank you everyone for participating in today's event. You will be redirected to our online exit survey shortly. We ask you to please take a moment to complete the survey as your feedback is very important to us. We thank you in advance for your feedback, wish you a pleasant morning, and hope to see you at another event by Attend the Education Network soon.